Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Notice is hereby given that a public hearing will be continued on June 24th, 2015 at 6 p.m. at the North Chatham Firehouse, Route 32, North Chatham, New York, to consider Adam Sloan and Life Youth Serve Foundation's request for a hardship waiver from Local Law Number 1 of 2015. All interested parties will be given the opportunity to be heard. Written comment will be accepted. Any other business to come before the town board will be heard at that time.
Before we go any further, just so everyone knows, the only emergency exits are these doors you can see here. Don't go that way because that's the truck bay and it's locked, so won't get out that way. Before we open the hearing, I just wanted to make a couple comments. I wanted to remind folks that this hearing is held for the purpose of hearing the public's thoughts on the Life Serve Youth Foundation hardship waiver application. It's not a hearing on Mr. Sloan's application for a special use permit from the Zoning Board of Appeals. It's also not a question and answer session, so we won't be getting into back and forth. The hearing is held for the purpose of the town board to hear civilized comments from the applicant and the public regarding the hardship waiver application. That's the matter before the board. So with that being said, I'd like to open the floor to Mr. Sloan and open the hearing. Adam?
Should I stand or sit over here?
Sure.
Oops, I'm sorry. Okay, great. Thanks. Do you mind if I sit here? Andy Howard is not here tonight because this was changed to another date, and he had a prior commitment. He's in another town meeting. So he did write out his opinion on some things, and Sally is going to read that, if that's okay. Just what Andy wrote. All right.
Could I just make one point of protocol? I had written to the town board earlier today about scheduling this and having non-redundant.
Right, we'll certainly make an effort not to be redundant.
And I will put it into the record, but if you recall, there was an opening March 31st public hearing. We were not given advance notice. Submissions were put in on that day. We were not, obviously without notice, able to rebut or to reply to the specific submissions. So we really believe that this continued hearing should focus on our ability to reply and rebut to what was already put in.
The public will have its opportunity to speak after Mr. Sloan talks.
Am I allowed to speak, Karen?
So
is that okay?
Right now it's his floor. So.
Right now, I just would hope that you would, schedule it so that there is not redundant use of testimony.
I'm just going to cover this piece of the unnecessary hardship. The local law establishing the moratorium provided that a person aggrieved could make application for a hardship waiver upon showing of unnecessary hardship. I understand that some have attempted to argue that the town board should now change this requirement. I would submit that the standard is clear, and more importantly, that we have met that standard. Prior to the enactment of local law number 1 of 2015, I spent over $1,250,000 purchasing the property at 206 Thomas Road, preparing engineering design plans, applying for the necessary permits, conducting the studies required by the Chatham Zoning Board in connection with the special use permit application, all for the specific purpose of starting an 8-week tennis camp. The breakdown is the $1,100,000 for the property, $117,500 for engineering fees, and $33,000 in various closing costs. We also had other costs that we've sent to the town board, breaking down the monthly carrying costs as well. The correspondence from the Chatham ZBA was read into the record at the last public hearing, clearly sets forth all the work that we did prior to the enactment of the moratorium. We have provided you with the invoices demonstrating that I have already spent $117,500 in consultant fees alone pursuing a legally permissible use in the town of Chatham, only to be stopped by this moratorium after the scheduling of a public hearing by the ZBA. This is money I cannot get back. It will be a complete waste of money if we are not permitted to proceed. This is money that was spent specifically to create this not-for-profit tennis camp. With no camp, there will be a zero return on the investment. The moratorium has also had a devastating effect on the LifeServe Youth Foundation's ability to secure donors in furtherance of the foundation's mission. In our April 2015 correspondence, we provided the town board with letters from 20 individuals who have advised the LifeServe Youth Foundation that they were suspending any donations to the organization as a result of the moratorium. The financial impact upon the organization in the form of suspended donations runs into the hundreds of thousands of dollars. The very future of our foundation is in jeopardy as a result of this moratorium. I have also provided the town board with proof of the carrying costs that I continue to pay to sustain the property while the project stands in limbo. Those carrying costs include monthly mortgage interest, propane, real estate taxes, and property and liability insurance. I believe that I have demonstrated the unnecessary hardship, the financial hardships that we have suffered as a result of this moratorium. But the unnecessary hardship runs beyond just dollars and cents. This moratorium, whose stated purpose is to stop larger scale development on dirt roads in the town of Chatham, is stopping a project that your own ZBA has said is not a large-scale development. It is stopping a project that involves the expansion of a septic field, something any residential or farming operation could do without review, the construction of tennis courts, again, something any residential property could do without review, interior renovations to residential and accessory structures. Karen, if you wouldn't mind, I'm just trying to do this, please. Thank you.
Excuse me?
I can hear you whispering. I'm trying to read this. That's okay. Thank
I
you.
think that might have been me.
No, it's
Regardless, everybody.
And you can
Thank you.
not
I'm
do
not
that
used to being
again.
in court like you are.
You are.
It is clear from all the information that we have provided from the detailed letters submitted by the Chatham ZBA that granting our project a waiver will not threaten the health, welfare, or safety of the community. It will not frustrate the primary purpose of the moratorium to limit larger scale development. What granting the waiver will do is allow a not-for-profit organization the opportunity to do good things for this community, to do good things for the children of Chatham and beyond, all in a small-scale seasonal tennis camp that will have no negative impact on our neighbors of this community. Please do not deprive us of the opportunity to do good work. Please don't succumb to the small but vocal outbursts from a limited number of people who do not truly represent the interests of the town of Chatham. I started this project because I wanted to help kids and help the community. Despite the financial and other hardships caused by the moratorium, despite the untruthful, slanderous things said about me and about these kids, all we are asking for is the chance to return to the planning board and ZBA for further review. All we are asking for is the chance to do something that will make the greater Chatham community proud. Regarding the purchase of this property, Linda Ziskin and others mentioned I received some special price break from the seller. To be clear, this property was on the market for over 4 years. Would any of you give a special price break to an out-of-town buyer you don't know? I want to just briefly cover two other things, and it does relate to all of this. It ties into it. Crellin Park, about 5 months ago, the members of the town board suggested we move the entire camp to Crellin Park. As Crellin Park is a public facility, we didn't feel it was appropriate to move the whole camp there. Building on the town's suggestion 2 months ago to alleviate concerns around construction of tennis courts and noise from tennis courts, we proposed moving the tennis portion of the camp to Crellin Park. Jesse and Henry formed a committee with the goal of seeing if Crellin Park would be a viable option for the tennis courts. Our foundation would build and donate the courts to the park, and we would be able to use them for approximately 4 hours per day during the summer. In doing our homework, we learned that over 30% of school-aged children in Chatham live below the poverty line.
This has nothing to do with hardship.
Excuse me, look, Adam said he's gonna tie it in, so we'll give him a minute.
It does tie in. It does tie in. Yeah. So, 5 new tennis courts would provide a huge morale boost to the park and the community. The high school tennis team would have been able to use them, as well as it would likely attract newer players to enjoy tennis. The courts would make you eligible to host regional tennis tournaments. It might even encourage others to donate money to the park. As we began our first committee meeting, the Alliance's leader, Karen Murphy, and others attended, and we all had a chance to introduce ourselves. When Karen finished introducing herself, she finished by saying, "You should know I'm in it to win it." It caught us all off guard and made everyone in the room uncomfortable.
How does this have to do with
We were there to work together, not in a murder trial. As we quickly learned, the Alliance wanted the courts at Crellin, but only if we moved the kids off the Thomas Road property. It has to do with it because it's related to costs of everything. We all took time out of our busy schedules to work towards something together, but clearly Karen had her own agenda. 2 weeks later, I heard the Alliance suggested that we were bribing the town by putting courts at Crellin Park. And now the tennis courts at Crellin Park are off the table. Simply put, this is a loss for Chatham and the kids in the area. Just a very brief comment about Rob Pitkowski stepping down, the volunteer fire chief.
This has nothing to do with the hardship.
It's fine. I'm good. I'm good. It's a sad situation. This guy gave everything.
And nothing to do with hardship.
It has a lot to do with this town.
Well,
You should feel terribly about him stepping down.
Mr. Sloan?
Thank you. I'm good. Thank you.
Would you let the man be heard, please? Thank you.
Thank you.
I'm reading the letter from Friedman and Howard.
Louder, please.
We can't hear you, I'm sorry. I can't hear you either.
You guys,
I'm sorry, I could not hear what you just
okay,
said.
I'll read it again.
Okay.
Don't attack me, please.
I'm just saying that we're just
You people make me embarrassed to be a member of the town of Chatham. I'm sorry. All right.
Speak louder. Sally, would you like me to read the letter?
No, I'll be
I've got a
fine.
booming voice.
He does, he's loud.
It's,
It's up to you.
that's fine, yeah. Thank you.
Thank you.
Yep. Thank you.
It's long. Okay. Dear members of the Chatham Town Board, I am writing in furtherance of my client's application seeking a variance from local law number 2 of 2015 and in response to recent correspondence with Karen Murphy at the Thomas Road Conservation Alliance. A. Standard of review. Karen Murphy's June 15, 2015 correspondence requesting changes to the language of local law number 2 of 2015 and/or the addition of criteria to the hardship waiver standard is without merit. Pursuant to Section 5C of Local Law Number 2 of 2015, the Town Board expressly provided that it was superseding Town Law Section 267, 267A, and 267B, and was exercising its home rule law powers in establishing the criteria that would apply to any hardship application. The Chatham Town Board utilized its powers under municipal home rule law, Section 10 and Section 10 of the Statute of Local Governments to supersede New York Town Law, Section 267B, thereby setting the standard of review for any moratorium variance application and empowering the Town Board to be specific body to hear such applications. In the absence of Section 5C, the Chatham ZBA would have been the body to review any variance application under Town Law, Section 267B. You get this, Tally?
I got it.
Okay. While the town of Chatham could have utilized a variety of standards in setting the standard of review, for one seeking hardship waiver under this local law, the Town Board chose to adopt the standard set forth in Section 5A. That standard requires an owner to show an unnecessary hardship and does not require or limit such proof to financial hardship. Thus, The advice given the town board by its council at the March 19th, 2015 town board meeting was correct. The unnecessary hardship to be considered by the board under this local law is an unnecessary hardship in accordance with language of the adopted local law. The fact that Ms. Murphy does not like this standard and would like the town board to utilize a different standard adopted by a different municipality and a different local law clearly runs afoul of the law and is completely irrelevant to this board's review and determination under the local law that was actually adopted. B, unnecessary hardship. As we have discussed, prior to the enactment of local law number 1 of 2015, Adam Sloan spent over $1,217,500 purchasing the property at 206 Thomas Road for purposes of starting an 8-week tennis camp, preparing engineering design plans, applying for the necessary permits, and conducting the studies required by the Chatham ZBA in connection with the special use permit application. The correspondence from the Chatham ZBA was read into the record at the public hearing on March 31st, 2015, clearly sets forth a voluminous amount of work, amount of work done by the applicant prior to the enactment of this moratorium. We have provided you with invoices demonstrating the applicant has already spent $117,500 in consulting fees alone pursuing a legally permissible use in the town of Chatham, only to be stopped by this moratorium after the scheduling of this public hearing. This money has been spent provides no economic benefit to the property if it cannot be used as a tennis camp. Under similar circumstances, the New York State Court of Appeals has held that the expenditure of $100,000 that may not otherwise be recovered constitutes an unnecessary justice justifying a variance. Jane Estates versus Rayner, 22 New York, 2nd Division, 417, 1968. The significant sums of money spent by the applicants, specifically in furtherance of a use that is permitted pursuant to section 180.13 of the Chatham Town Code, is money that simply cannot be recovered, as it was spent in order to further a legal, legitimate use of the property that has now been suspended. The expenditure of over $1.2 million before there was even a hint that a moratorium was being considered justifies a finding of unnecessary hardship and the grant of the hardship waiver. Notwithstanding the aforesaid financial hardships, as we discussed at the March 31st, 2015 public hearing, and set forth in our April 7th, 2015 correspondence, this moratorium has also had a devastating effect on the Life Serve Youth Foundation's ability to secure donors and furtherance of the Foundation's mission. In our April 7th, 2015 correspondence, we provide the town board with correspondence from 15 individuals who have advised Adam Sloan and the Life Serve Youth Foundation in writing that they were suspending any donations to the organization as a result of the moratorium. The financial impact upon the organization in the form of suspended donations runs in the hundreds of thousands of dollars, all as a direct result of this moratorium. See April 7th, 2015 correspondence with exhibits. The applicant has provided the town board with proof of the carrying costs that the applicant continues to pay to sustain the property while the project stands in limbo. Those carrying costs include monthly mortgage interest of $2,466.08, propane of $4,066.33, real estate taxes of $27,796.77, property and liability insurance of $12,500, legal expenses for a 501c3 application of $2,821.50. See April 7, 2015 correspondence with exhibits. Thus, it is respectfully submitted that the applicant has clearly demonstrated the unnecessary financial hardship under which it has suffered as a result of this moratorium. Finally, in addition to the financial hardship, the applicant has further suffered unnecessary hardship because it has been swept
up in a moratorium that is truly directed at large-scale development projects, not an 8-week summer tennis camp involving the minimum is development activity. Okay, that was de minimis.
That's exactly right.
Yeah, he misspelled it. As we have previously stated, the law in New York is clear. While a municipality may utilize its police powers to impose a moratorium, it must only do so where there is an immediate threat to health, safety, and welfare of the community. And a municipality may only impose a moratorium that is narrowly tailored to address the delineated threat. Bell Harbor Realty Corporation versus CARE, 35 New York, 2nd Division, 507, 1974. As the Court of Appeal expressly held in Bell Harbor Realty Corp., consequently, a municipality may not invoke its police power solely as a pretext to assuage strident community opposition. To justify interference and beneficial enjoyment of property, the municipality must establish that it has acted in response to a dire necessity, in bold, that its, in bold, action is reasonably calculated to alleviate or prevent the crisis condition, and that is, in bold, presently taking steps to rectify the problem. When the general police power invoked under such circumstances, it must be considered an emergency measure and is circumscribed by the exigencies of that emergency. Emphasis added is the bolding. Bell Harbor Realty Corp. versus CARE, 35 New York, 2nd Division, Act 512. The Life Serve Youth Foundation Tennis Camp application is the only application before the town of Chatham seeking a special use permit and a site plan approval on an unpaved road. No other applications are before the town of Chatham Zoning Board of Appeals or Planning Board. It is respectfully submitted that there is nothing in the record evidencing the existence of a dire necessity, emergency, or dire threat posed by this application. One application seeking a special use permit on an unpaved town road does not constitute a dire necessity, especially when the proposed use will occur for a limited period of time each year on a property that has already been developed. As we have pointed out, while local law number 2 of 2015 has effectively halted certain types of developmental activity, despite the moratorium, a property owner in the RL2 zoning district can currently construct 2 single-family homes on a property, construct a plethora of accessory structures, construct as many agricultural barns, sheds, and buildings as a property will support, and engage in large-scale farming operations without any review from the town of Chatham. Nor is such activity circumscribed or prevented in any manner by local law number 2 of 2015, see Chatham Code section 180-13. As we have further pointed out, heavy farm equipment, milk trucks, construction equipment, and construction supply delivery trucks can all utilize Thomas Road outside the reach of this moratorium without any municipal review and without any bond or security being put in place. Finally, the Chatham ZBA has provided compelling correspondence that was read into the record, which made it clear that in their view, as the lead agency in the review process, the Life Serve Foundation Tennis Camp project does not present a dire threat to the health, safety, and the welfare of the community, but rather the applicant has submitted a complete application addressing the concerns of the community as expressed to date. I'd encourage the town board members to again read the Chatham ZBA's correspondence in contemplation of their vote of this application. Pursuant to the foregoing, it is respectfully submitted that the applicant has made the requisite legal showing to the Chatham Town Board demonstrating its right to a variance. Montgomery Group LLC versus Town of Montgomery 4AD, Division 458, 2nd Department, 2004. Like the plaintiff in Montgomery Group LLC, the applicant herein has demonstrated through competent proof that it will suffer unnecessary hardship should it not receive a variance from local number 2 of 2015, that granting a variance will not adversely impact the health, safety, and general welfare of the town of Chatham and will not substantially undermine the zoning revision process. The Thomas Road Conservation Alliance has failed to come forward with any credible evidence establishing that the applicant is not suffering under unnecessary hardship or that the establishment of the tents camp at 206 Thomas Road will in any way threaten the health, welfare, or safety of the community. We therefore respectfully request that the Chatham Town Board grant this variance application and permit the applicant to return to the Chatham ZBA and Planning Board for further review of this project in accordance with the salient provisions of the Chatham Town Code. Sincerely yours, Andrew B. Howard. I don't have to read another
Sorry.
thing.
Sorry. Thanks.
You're welcome.
Okay, so the floor is now open for further comments. I would ask for our newspaper reporters' edification that you please state your name and our town clerk's edification, that you state your name prior to speaking. That's it.
I'm counsel. I'd like to speak first.
Actually, Jim Temple had his hand up first.
No, I'm the counsel, and I think that I need
Okay,
to.
Jim, would you like to yield the floor to Karen?
No.
Okay.
Jesse, I'm the counsel for
Well, that's
the
fine,
group.
but Jim had his hand up first, so we'll let Jim go first, and then you can second.
My name's Jim Temple. I'm a 68-year resident of the town of Chatham.
Can you speak up? I can't hear you.
I'm a 68-year resident of the town of Chatham. My parents are permanent residents of the town of Chatham. They are next door. I listened to the concerns of the Thomas Road Alliance very carefully. It was explained to me by one of the Alliance members. I probably spent 4 hours listening to him. I don't know Mr. Sloan. I introduced myself to him this evening. The turmoil that's going on here is not part of the town of Chatham that I grew up in. In that environment, I was taught to rely on my neighbors. Rely on my neighbors. I was taught to trust my neighbors. So I respectfully request the board to trust what Mr. Sloan is saying here, that he does in fact have a hardship. I don't know what's in his heart, but I trust him because that's what he said. He has a hardship. So I would hope that you would send this back to the Zoning Board of Appeals and let them see this through to its conclusion. Whether his application is approved or disapproved. Let's put this behind us. Thank you very much.
My name is Karen Murphy. I'm a member of the Thomas Road Conservation Alliance, but I'm also serving as co-counsel for the opposition to the application for a hardship. We also were responsible for supporting this town board in doing the right thing by implementing a moratorium that protects all of you. We were also supportive in connection with that to preventing this particular project from being accepted from the moratorium because of its significant impact on the assets the moratorium was trying to protect, which is our dirt roads. And today we're here not because we don't believe, in our hearts anything about Mr. Sloan or the project. We're here because there's a legal standard that has to be adhered to. It's not about taking a leap of faith. If that was the case, there would be no reason for government. And there is a reason for government. And there's a reason for the process. So we would like to first present for the board's consideration a letter that was written by Eric Young, which the board may or may not have read before today's meeting, and it explains the legal standard as Mr. Young understands it as a lawyer, and as I will discuss with you momentarily. I would also like to present to the board all of the letters that have been put into the record. Again, it's common law, it's statute, it's practice. Hardships have criteria in moratorium law all the time. And that's because people need to know what they're judging. You need to know what you're supporting or you're objecting to. Otherwise, it becomes a subjective determination, and it cannot be a subjective determination. It must be an objective determination. So we ask this board to provide criteria to guide you and to guide us. And
Copy of the paper at the end of the board members?
huh?
Have a copy of the other paper at the end of that?
Did you get it? I'm sorry. Huh? I don't say it. I'll check at the
I
end.
have the email.
Again, just so the board has before it, the letter requesting, all of which has been CC'd to council, requesting the criteria, and also explaining that at the same time that this is going on in the town, the village has a comprehensive plan, has a moratorium, has in its moratorium criteria that are objective, that you have to meet in order to be able to get a hardship. It's not believing in your heart. That's not the criteria. It's satisfying a financial hardship, among other requirements. And these are all the letters that were supplied to the board prior to today. And I'll hand that out at the end, okay, so that's time. The statement I have, which paraphrases somewhat that's in the letters that the board has already had, but also Mr. Young's letter. The February moratorium was adopted for the protection of this town's citizens, all of its citizens, and the town's important and signature assets. I'd like you to raise your hands if you're here on the no hardship opposition group. I wanted the town board to see that we do have a substantial number of citizens that are here supporting the position of no hardship.
You're asking for comment from the floor on that. I think that would be appropriate.
I'm sorry, no, we're
She
not.
asked for a comment for the floor.
Okay,
I'm going back to her.
that'll come later. Ted,
I think
Ted, one person at a time. No question and answers.
Protecting its citizens and protecting its assets, signature assets. The point was to slow it all down. It doesn't mean it stops it. It doesn't mean it can't go on after the moratorium. Just slow it down so that the public could participate in the implementation of our hard-fought-for comprehensive plan, to get it done right and to get it done smartly. In connection with the moratorium's adoption, this board debated and denied accepting Mr. Sloan's proposed not-for-profit tennis camp project, a project for which he has not obtained the required permit. This is an application by Mr. Sloan for a hardship, not LifeServe Foundation. Mr. Sloan owns the property. Mr. Sloan does not have the right to build on this property what he proposes to do. He has to get government's approval. He does not have that approval to develop, nor is there proposed activity some sort of fundamental right that the moratorium has interfered with. There's no fundamental right to a proposed tennis camp on this property. On the contrary, regardless of whether this is a good cause or an appropriate use of the land, Mr. Sloan is not being subjected to any costs, any economic loss, or any interference with the natural and permitted use of this property. What then is the claim? That he has some inalienable right to build a not-for-profit commercial project at this location, and that if he is delayed, he is doing so, he'll face the hardship. Well, we know one thing from the law, and that is that delay is not a hardship. Absolutely not a hardship. So that can't be the basis for this board granting the hardship. He has full occupancy of the land and all the permitted uses that are associated with it, and has in fact taken advantage of that use without any interference by the moratorium. Could this be an economic hardship? The proposed project is not his business, and it will not generate any income for him, other than potentially reducing a substantial tax burden to him to the detriment of the town. Now that's not an economic hardship, that's an economic windfall. With all of the questions associated with the hardship determination, and the unhelpful suggestion by town council that a hardship can mean anything, we respectfully ask the board to publicly debate, and adopt specific written criteria in advance of today's hearing. We did so to avoid the inevitable, subjective, ad hoc decisions by individual board members, which in no way and stands starkly in contrast to the moratorium law in place in the village, where express objective criteria are in place to guide the decision making. With no response to our request, we are still left with fundamental guidelines. They're under New York law, common law, among other law. And that requires a factual showing of actual hardship, that the effect upon Mr. Sloan is substantially greater or more harsh than others subjected to the law. He must factually show that. That showing cannot be met, as Mr. Sloan, who is a sophisticated real estate investor, knew that the property was not available for the proposed project without first obtaining a special use permit. And he knew that there would be costs associated with obtaining that permit, and that those costs could be substantial. Sloan's original transaction for the property was contingent upon obtaining the permit before he actually purchased the $1.35 million estate. Mr. Sloan opted to purchase the property outright because of an exchange by the seller of a substantial price reduction in the amount of about $250,000. This is important for two reasons. First, Mr. Sloan knew going into the deal and prior to the sale of the potential costs, and to now argue that he might have to pay some small portion of those costs, for which he has extracted a substantial savings on the purchase price of the property, constitutes a hardship, strains credibility, and completely undermines any definition of hardship, any definition. It also seems to challenge the intelligence of this community and the intelligence of this board. Secondly, and as certain members of this board recognized, the March 19th meeting, there needs to be a showing of why this particular applicant would be burdened requiring some sort of assessment as to his financial health, or as both the supervisor and town board member, Ms. Lull, called out for a review of Mr. Sloan's financials. There has not been any showing of those financials, and therefore Mr. Sloan's burden of proof on the waiver request has not been met. It's a burden of proof that you must meet in order for this board to not be subject to any kind of threat of litigation or any kind of concern. The town has to be concerned about whether they got it right. They have to get it right, and they have to get it right under the law. And that's his burden, is to prove it financially through his financials, and he never came forth with that. Since he hasn't met the burden on any level, it has to be denied. It's not a question of picking and choosing. It must be denied by this board. He can wait his day until after the conclusion of the moratorium, like everyone else. Nobody's denying him anything. He assumed the risk, he took the risk, he either made a mistake or he's going to have to wait a little bit, but that's what happens when you go into a real estate deal eyes wide open. I'm reminded of Alice, which I've just read recently, and I implore you, the town board, please do not do as the Queen of Hearts famously declared. Sentence first, verdict afterwards. Listen to your citizens, they're here tonight, and do the right thing.
Ted, did you take the opportunity now?
I don't want to repeat anybody else's, but if you want, you got it.
Well, you were ready to go before. So.
All right, Ted Miner. And I guess I have many family members who are permanent residents in this community as well. Sure. Moved back in the area 35 years ago to raise many children in this area, part of a couple families, of which lasted 15 odd years ago, with becoming part of and living a lifestyle 365 days a year, part of a nonprofit that lives as we speak and speaks as we live. I guess is the best way to put it. Those young familiar with it, I'm sure Lynn could clue in on that later. At the end of the day, we never asked for tax breaks to live our lifestyle. I wish, I've been to several different committees meetings. I have looked for and requested a mission statement from Thomas Road Group, and I'm challenged to find it yet. I looked for, and I'm sorry I never met you, sir, but I looked for a couple hours a mission statement for your group, and I couldn't find it. I saw a filing with New York State, and that was it. I didn't see what you were planning to do or how you were going to get there, and that bothered me. I guess my foundational concern is that I wish Mr. Sloan had pursued your activity as Mr. Sloan. And I think there's not a soul in here that knows me that knows that I might be a little liberal, and if you own a piece of land, you should be able to do on it what you choose. And there's a couple in here that would regret that by me. At the end of the day, though, sir, if you'd have done it under your own name, it would pack so much more punch instead of asking for relief from those of us who may not care or just be a taxpayer. Asking the general public of us as taxpayers to help fund your stock. In other words, I'm not looking for a tax break to do this. I'm challenged with that. And I'm challenged that right back to my foundation and the way I live and those around me. Those I choose to be around me. And I thank you.
Thank you.
I wish you had done it yourself. Thank you.
Respond to some of, will I be able to respond to some of the comments later?
Yeah, we'll give you a minute.
I'll be real brief. Thank you.
Yeah, we'll
Thanks.
give everybody
Yep. Thanks.
But by the way, I'm not saying it would have, should have, could have passed one way or the other. It should still go down the right alleys and get settled by, and furthering the comments previous. Karen raised a lot of seriously good points. I wish you had to ask for hands around. But it would have been so much easier and so much cleaner to have done it just simply under your name. This is what I want to do. This is how I want to do it. I'm not asking for relief or funding. I'm just going to put it together and get it done.
Thank you. So I'd like to start by reminding everybody on the town board about the specific wording from the moratorium. Karen mentioned that a delay does not constitute a hardship. She also mentioned that there is really no criteria for hardship in the moratorium, and she's right, there is no criteria in the hardship for what a moratorium is. There is, however, a very clear statement about what a hardship isn't. And this was a line from the moratorium that was adopted by the Chatham Town Board on February 19th, 2015 by a vote of 4-1. Town of Chatham Local Law Number 1, 2015 with hardship section 5. Section 5 reads, for the purposes of this local law, unnecessary hardship shall not be the mere delay in being permitted to make an application or waiting for a decision on the application for a variance, special use permit, etc., during the period of the moratorium imposed by this local law. And I think that's pretty clear, that all of the delay issues that Mr. Sloan is claiming hardship for, according to the law, it's not a hardship claim. The moratorium was meant to protect those of us living in the town's farm and residential areas. You, the town board, enacted this temporary moratorium for special use permits on dirt roads. You did this in order to ensure that all such projects will conform to the town's new zoning laws that will be based on the comprehensive plan and not be judged by the zoning laws that we currently have, which are woefully outdated. The statement read from, I guess it was from Mr. Sloan's lawyer, talked about all kinds of permitted uses. And by permitted uses, I'm sure what he really meant to say was uses permitted by a special use permit that is approved by the zoning law. Because as Mr. Sloan, or contrary to what Mr. Sloan seems to imply, a special use permit isn't guaranteed. You can apply for it. Most people do spend some range of money on engineers and other consultants to help them through the application process. But spending money isn't a guarantee of approval. It's just part of the process that you go through. If you consider Mr. Sloan's expenditure of $100,000 on his engineering firm a hardship, then I guess you've pretty much eviscerated your own moratorium. You've created a back door. You have said that anyone who applies for a special use permit and spends any amount of money on consultants to help navigate that permit through the ZBA has a hardship. So what's the purpose of the moratorium? Mr. Sloan is very concerned about getting this hardship waiver so he can proceed before the new zoning laws are enacted. Now, the comprehensive plan runs, what, 80-some pages? So I don't know who's in the room has taken the time to read it, but if you do read it, one of the things you'll read is that while the comprehensive plan says there will still be special use permits in RL1 and RL2, that's Rural Lands 1 and Rural Lands 2, and by the way, permitted zoning for RL1 and RL2 are agriculture and low-density residential. Everything else, including trailer parks, vacation home parks, special camp, outdoor movie theaters, they're all cluster housing, heavy industry. It's all permitted through special use permit, and you have to prove that you're meeting the intention of those zoning requirements. But here's something weird about the law as it exists now. It doesn't give any special requirements. So if you want to do a tennis camp, you can do a tennis camp. There's no acreage requirement. There's no requirement for, say, if you're going to do a commercial tennis camp on a property that has a 1,500-foot driveway that is on a 15 to 20% grade. There's no requirement that that has to meet any kind of fire safety code. You just have to get a letter from the fire chief saying trucks can get up and get down.
Linda, can I just remind you that you're addressing the board?
Yes, I'm sorry. It's just that you already read the stuff, but I do apologize. So the new zoning laws are actually going to be quite different. One of the things that the comprehensive plan says is that they would like to see an acreage requirement for summer camps. And in reading the ZIC minutes, we found several references to the fact that the ZIC had approved a proposal, because the ZIC, in case anybody doesn't know, is the Zoning Implementation Committee that is putting together recommendations for new zoning laws based on the comprehensive plan that will be presented to the town board. And the ZIC, in the ZIC minutes, in several instances, they said they approved a proposal to present to the board that there will be a 50-acre minimum on summer camps. I don't believe Mr. Sloan's property is 50 acres. So if he's in a hurry to get his camp out of the moratorium, his proposal out of the moratorium and into the public hearing for the ZBA, it could be because he'd really like to get it approved under the old zoning laws. The other question is, as Karen mentioned, how are we going to be judging Mr. Sloan's request? There are no criteria, except for that clause about the delay not constituting a hardship. Criteria for the hardship waiver exemption was never really written. In fact, the town board's lawyer announced that publicly, that the beauty of the hardship waiver is that it's whatever you want it to be. Well, whatever you want it to be means that it's arbitrary. And that means you're deliberately keeping the hardship arbitrary, and laws aren't supposed to be arbitrary. The rule of law holds that law should govern a nation, as opposed to being governed by arbitrary decisions of individual government officials. To date, Mr. Sloan hasn't presented any credible evidence for hardship. The money that he's laid out for his engineers is money laid out for every person who's navigating a special use permit application through the ZBA. The delay in getting his nonprofit off the ground, well, it's written into the moratorium that delay is not an appropriate cause for hardship. And the fact that he presented at the last meeting that he pays taxes on the property and he pays for upkeep of the property, he gave you his gas bill. Well, I'd like to give you my gas bill too, and my tax bill, and my electric bill, and my lawn mowing bill, because I suspect that everybody in this room who owns property pays taxes and pays utilities. Mr. Sloan's nonprofit did not buy the property. Mr. Sloan bought the property. He has enjoyed that property on multiple weekends and during the week as a second residence. And it doesn't matter if you're first or second residence, you own it, you gotta pay for it, not a hardship. If you award Mr. Sloan a hardship waiver, you violate your own law and you make a sham of the moratorium. If you circumvent the moratorium, a law meant to protect us, you send a message to the community that there's a back door to the moratorium. Just claim that any money spent on filing your special use permit application is a hardship. And then anyone who wants their special use permit approved under the old zoning laws can walk right through it. Thank you.
Thanks, Jessica. I'm going to take my time to read a letter that my wife wrote. She was unable to be here.
Can we get Bob to read it?
What did you say?
Oh, I have to do something else. I love these meetings when everybody talks about all the years they've been in Chatham. This makes you somehow special. So I would like to note I've lived here for 37 years. I have lived on Thomas Road in the same house, quite near this proposed camp for all of those 37 years, and have both enjoyed my home and have watched our road become busier, more crowded, more congested as the years have gone by. And I will try to read it myself, but as loud as I can.
Your name, please?
John Wacker. Dear Supervisor DeGroot, Mr. Balcom, Ms. Lull, Ms. Rohde, and Mr. Swartz. I'm writing to you to consider the following information as you vote on Adam Sloan's hardship request for his proposed tennis camp on Thomas Road in Old Chatham. Unfortunately, I will be unable to attend the meeting on 6/24/15 due to a death in my family. As you well know, Mr. Sloan's quest for a special use permit for the proposed camp was interrupted by the town board's vote to grant a moratorium on approvals for all special use permits in residential areas on dirt roads. The board's discussion centered on the anticipation that the revised zoning laws are soon to be released by the ZIC, and that those revised laws are a better measure of suitability of certain types of development, especially in the quintessential rural areas of the town. Your forward thinking was welcome, and your commitment to the principles of the comprehensive plan, which hopefully will be visible in the proposing zoning legislation, was important to planning for the future quality of rural life for the town of Chatham. At the time you approved the moratorium, you specifically considered whether to have an exemption and a hardship waiver included in the law when you approved it, and decided to only allow requests for hardship. At the same meeting, the board denied Mr. Sloan's request for an exemption from the moratorium and decided against allowing anyone to apply for this type of exemption under the moratorium. At the time, it was apparent that the criteria for the exemption are less stringent than criteria for a hardship. Your denial of his request seemed to eliminate any possibility that could meet criteria for a hardship, as it is typically defined. Now Mr. Sloan has circled back and is requesting that the board grant him a hardship waiver for his project. I do not believe there is any evidence that Mr. Sloan had suffered any financial hardship during this long process of trying to secure a special use permit, which is the standard criteria for hardship waivers. Certainly, the delays have been frustrating and the process difficult, but that has been true for all the citizens who have been involved in this controversy. As you all work to balance the needs of the town, of the town citizens, I will be looking for your thoughtful and fair consideration of Mr. Sloan's appeal. I hope you apply some definable criteria for hardship, make it at a public meeting, and measure his situations against those standards. For the sake of the qualities we love and cherish in our rural landscape, I hope that you all maintain your original intention for the moratorium. Thank you.
I'm going to get this up on my phone. I'm Heather Euler. I live at 263 Thomas Road. I recently had the opportunity to speak with Bob Summers. He is a PhD for agriculture markets. He is in charge of writing agricultural law. And I asked him what constitutes a hardship within a state-designated agricultural district. And Mr. Summers basically gave me 4 criteria. The first is that the applicant must prove that the property is unable to achieve a reasonable return in any use allowed in that zoning district. Number 2, the applicant must prove that the unique circumstances apply to the property for which the variance is requested. I don't really know how that property is unique to tennis. Sorry. Number 3, the applicant must prove that the hardship is not self-created. And number 4, the applicant must prove that the essential character of the neighborhood will not be altered if the use variance is granted. In an effort to protect the lands from inappropriate usage, it is agriculture and markets rule that the applicant must not meet some, but all criteria in order for the hardship to be granted. Mr. Sloan has met none. Thank you.
Anyone else? You want to wait till?
Whenever you suggest.
Yeah, I mean, please.
See, this gentleman over here. Oh, there we go.
Hi, Jeff Murdoch, Reed Road in Chatham. I actually support the idea of a tennis camp. I think it's a great idea. However, we're at this point where it's a hardship that seems to be the issue at hand. And it just doesn't make sense to spend $1 million without the permits in hand to go ahead and do a special permit type of project. So if you go ahead and do that, in my world, if I was in this situation right now, I'd be kicking myself because I would call that a mistake. It's plain and simple. It's that simple. I made a mistake. A big one, albeit. But if you need a special permit and you move ahead, you don't have that permit in hand, that is not a hardship. You made a mistake. I've made a lot of mistakes. I've never made $1 million mistake, but I've made some expensive ones. And that's just the way it is. And I support the moratorium. I support a tennis camp somewhere where it's appropriate. I think taking care of kids, bringing kids out of the inner city is a great idea. And having that happen in the town of Chatham, and having the town support that would be terrific. It would be great for everybody. But we're at a certain point. You have a hardship issue. He bought a piece of property without a permit, and he needed a permit. He made a mistake. In my mind, it's that black and white. Thank you.
Angela from Old Chatham. To speak to that issue, and someone here in front of me knows about it, is that the Quaker folks bought a piece of property and spent a lot of money on it, and they needed a special permit, and it was a long process for them. And you know, they worried about it and complained about the money they had to spend and wondered if they were going to get that special permit. And people wondered the same thing. Hey, you spent a lot of money on this piece of property and you needed this special permit. And they worked with the community. We all worked together, and they have this beautiful meeting house now. But it took a long time to get there. I guess my question is if not for Mr. Sloan's proposal and the opposition to it, would this board have enacted the moratorium? I mean, the new zoning laws, or what do we call it? What's the comprehensive plan? The comprehensive plan has been around for what, 5 years? Or more than that. Was it Mr. Sloan's proposal itself that prompted this? I mean, I guess I'm confused, and I'm just dismayed by just what's happened in this community as a result of this. It just doesn't seem like the community that I moved to and the community that I really love. I don't think we need the rancor and the hatred that I have seen as a result of this. I mean, Mr. Sloan has agreed to pay taxes year-round for a nonprofit. He is a bit. Please let me finish. So I'm getting to the hardship. Just following this and coming to, I've been to a number of meetings here. I just assumed that he's had to he went before the zoning board, he went before the planning board, he was this close to getting a special use permit, and I've been to many zoning board meetings. I have great respect for that group, that body. But would you have gone ahead with the moratorium if not for this project, since the comprehensive plan has been around for a while?
Well, like I stated at the beginning, it's not a question and answer period, so
I guess if I were him, I think that each step, I mean, he's trying to get it done. So if this was the next step he had to make, it makes sense to keep going. Considering all the back and forth that's been going on between him and the Alliance. So, but I really truly hope that in some way our community can heal from this, and I don't think that the rancor is necessary.
My name is Mike Bragg. I'm from County Route 17. I've been a resident for about 50 years. I'm going to read a letter from a resident of the town of Chatham. To the town board, we're sorry that we are unable to attend the hearing tonight. We strongly oppose granting a hardship waiver to Mr. Sloan, and we hope that the town will represent us by denying the waiver at tonight's hearing. And personally, I would just like to say, encourage Mr. Sloan through the process to work with the town and specifically the residents. If you're denied the waiver tonight, just like myself and everybody else in the room, you have to work with the residents and the local people on the road. I think that if you had done that, perhaps we would have had a different outcome. So I would challenge you and the board to work together in the confines of the law and with your local residents. Get to know your residents, the people that have the concerns, and specifically people that may not be on the road. I personally would not endeavor to build anything on my property without getting the buy-in with my neighbors. I have to live there. Why would I want to live somewhere where my neighbors don't like me? I challenge you. If you're denied tonight, take it to the board, take it to every resident on that road and ask them for input. Because I bet you're going to get approved. It may not be next week, next year, next month. It may be a year or two, but you may get what you want, but it may be a slight deviation. Back to everybody that said, Mr. Minor, Mr. Temple, they all said basically the same thing. You have to live with your neighbors, and what Mrs. Murphy said, the law is black and white. Either you violated it, and the town is not going to allow it, or there's a loophole and you can get it approved. But I believe that it's black and white, and they will vote correctly. If they vote and you vote me down for the hardship, go back to the drawing board. I'm an athlete. I love sports.
Mike, I'm sorry, but again, these are comments directed towards the board, not
so
Mr. Sloan.
I challenge the board and Mr. Sloan to work together and to resolve the issue.
Who wrote that letter? Who was the letter writer?
Geraldine and Philippe Marielle from East Chatham.
Thank you.
My name is Lucinda Buckley. My husband and I live in Malden Bridge. We have not taken a position one way or the other with regard to the Thomas Road issue, Mr. Sloan. I share Jeff's thoughts personally. I think Mr. Sloan has a great idea. I think it probably could be in a better location. But we're here tonight about the moratorium and the comprehensive plan that this town has invested thousands of hours and dollars into to make this town and preserve the town the way that we like it. I am heartened by the moratorium, putting that in place to make sure that something doesn't happen before we have the opportunity to comply with a comprehensive plan. I've been hoping for 10 years we get the compliance with the comprehensive plan and have things more in place along the lines of what we all hope for this community. Unfortunately, it took Mr. Sloan's project, or maybe another project, or two or three, to call to our attention the need to just say, stop. What's going on here? We value our dirt roads. We value the rural nature of the community. Since my husband and I moved here 19 years ago, the traffic has increased significantly. We ride horses on the dirt roads. We ride horses along the side of the paved roads. There are more cars here. The cars are going faster, building more businesses, more commercial activity, and taking away our dirt roads is going to significantly change this community. And I applaud you for taking the step of saying, stop, let's think about this before we do anything further. I agree that I don't think Mr. Sloan has demonstrated a hardship, and some of the criteria that's been cited by Heather and Karen and Linda is, in my mind, as a former development attorney, consistent with where the board should be going with this. And so I apologize for the bitter response you've gotten in this community. I don't think that shows the nature. I'm sorry. Okay.
Thank you.
But thanks.
Well, I'll stand up. I'm a college professor, so I'm used to speaking.
Your name, ma'am? I'm sorry.
So, well, they would never be able to spell it. It's Jonna Senex is what it is. I haven't lived here long at all, so probably most of the people at this meeting would think, well, she shouldn't even be speaking, because I only lived here for 2 years. My daughter and I bought a house in the hills outside of East Chatham. I'm not going to say what I think of what's going on here, because I don't know all the facts in the way that other people do. I will say that I think the town should be careful about issuing special use permits. And the reason that I feel that way is that in the process of looking for a house to buy up in Columbia County, I personally looked at 36 different houses, and I was getting pretty tired of it. So we finally found a house, or I found a house that I thought my daughter would like, and it was on a dirt road, off a dirt road, etc. And I was all ready to buy the house. I liked it a lot, although I hadn't consulted her yet. She was certainly part of the process. And only when I did a Google search of the surrounding area did I discover that about a third of a mile or half a mile along the road was some sort of corporate facility, which had a parking lot large enough to fit probably about 80 cars or something like that. And I called the real estate agent and I said, what is the zoning in this particular area where this house is? And she said, well, it's residential. And I said, well, there seems to be some sort of a corporation with several buildings and so on. What is that? And she said, oh, you don't need to worry about that, because that company is no longer in existence. It failed. I said, what kind of a company was it? Was it manufacturing? No, it was some sort of internet company. And I said, well, there were 5 or 6 cars in the parking lot. If it's not being run as a business any longer, why are there 5 or 6 cars? She said, they're probably just keeping an eye on the property. People who were paid to keep an eye on the property. So I called my good friend and I asked him about it, and he said, let me do some research. And he called back and he said, that's a special, and also when I called Chatham, they told me this, that's a special use property permit that was granted something like 40 years ago to either an ancestor of the person who now owned the property or to someone else from whom he bought the property. And I said to the real estate agent and the person at the town hall in Chatham, whoever it was, I'm sorry, I cannot tell you what her name is, we bought a different house anyway, which my younger daughter liked a lot better, and so did I. But I said, is there a possibility that because this special use permit was granted and it's passed along with the property, the owners can change. It's passed along with the property as it's sold. So I said, can you guarantee me that no one will turn this property into a manufacturing facility and there will be 80 cars on this road every day passing by my house? And they said, oh, don't worry about that, because there isn't the infrastructure to support 80 cars driving along that road. Who would do such a thing? Who would start such a factory there? No one would do it. And I said, can you guarantee me that it will never happen? And they said, no, we can't guarantee that. With a special use permit, anything could theoretically be possible. So my concern is not really specifically with the moratorium, though I think it's always good to take one's time. Of course, I'm from the academic world, and we really take our time. We have a different definition of time. Because what you do might last for another 80 years. In that sense, that's the obligation that I think the board has, and everybody in the community has, to think about that. This is not a criticism of an attempt to, you know, create a tennis camp for kids, but what if Mr. Sloan sells his property 15, 20 years down the line? Okay, okay, all right, I'm
We're
sorry.
here to discuss hardship,
Only
however,
addressing,
not yet.
Well, that's all I have to say.
Okay, thank you.
Yeah.
Okay.
Because I think it would help. I'm only going to respond to what people have said to make it easy. I apologize. I forgot the gentleman that mentioned to work with the residents, and it was advised very early on, even before I bought the property. So the first thing I actually did, because I actually spoke with the zoning board, they suggested I speak with the residents. I happened to go across the street. I had no idea who lived there, and the first person I talked to was Karen Murphy. And I went over and said what my plans were, and I'm actually not going to say the response, but it was startling. And but you want me to say it? I'm happy to say it.
No, but this has nothing to do with hardship.
Okay, really, hold on. Yes, hold on. It does. I'm responding to people in here. So 2 days later, I got a letter from their attorney saying not to talk to the residents. They formed an alliance, and that I was not supposed to talk to them. So I was trying to work with the residents. I actually went around knocking on the doors, including Mr. Wapner's, a lot of people. They weren't home. I'm going to finish, and you're welcome to go. So I tried to do that, but I got a letter from their attorney asking me not to speak with any of them.
No, not speak with them before, without seeing him. That's all.
Wait a minute.
That's just not
It's all,
Jesse, you're
but that's the response I got. That's the response I got back. Please don't approach them, approach me.
It's just false what you're saying, and it's
Number
not
two.
relevant to a hardship.
Stick with the hardship.
Yeah. Okay, I have a big part of the hardship to come. So, as far as spending $1 million early on, to be clear, I went to the zoning board meeting and spoke with our attorney engineering firm, and the ZBA people said that it would be it could be a long process and a tough process, but you're within the scope of the law. That doesn't mean they were going to approve it, by the way. But they kind of let me know that, and I felt comfortable from going to that initial meeting before I bought the property that I was operating within the law and I would spend the money. Number 3, and most importantly, there's a process here in Chatham to get approved. Anything has a process to get approved here, and all the boards are aware of it. And the process is we're supposed to go to the Zoning Board of Appeals and then to the Planning Board to get our project approved, which is exactly what we did. So we did this many, many months ago, and I have to say, if the moratorium, and here's our hardship, if the moratorium was created very early on in the process instead of many months down the road, I would have never spent the $100,000 on legal bills and all this other stuff, flying from Florida to Albany to come to a meeting. Which was disappointing, and more legal bills had to prepare for the town board. We were following a process here, and we're the only ones that got out of the process, which is what you were saying, and it's correct. I would never have wasted over $100,000 because if the moratorium was created very early on in the process, I would have just stopped, and I would have had to wait. But instead, I spent $100,000, and then I got thrown into a moratorium. That's a real financial hardship. As for taxes, these people are willing to say things over and over, and I'm sure some of you aren't aware, but I've said it many times in the zoning meeting. I've actually said to this town board meeting, it's actually written in the newspaper. We're willing to pay taxes on the property. So I don't know how many times I have to say it. I
80%,
apologize, I'm not being disrespectful.
Not 100% taxes though.
And again, this is not.
Not 100% of our taxes, but how many other nonprofits go there? Anyway.
Right here.
Well, are you paying 100%?
You got it.
Okay, I mean,
Millions of dollars, good sir.
Guys, can we get back to
Yeah.
addressing the board
Yes.
on the hardship and then?
Yeah,
we'll-
and then the last piece, because that's important. The last piece is that Karen.
Here we go again.
No. This is important. This is a hardship. These are real numbers. I bought the property for $1,100,000. Can anybody believe that a guy from out of town is going to come? This is important because you tossed the number out.
Madam, the board.
I'm sorry. That a guy from out of town would come into Chatham knowing no one, and the seller who's got her property for sale for 4 years all of a sudden feels like being good-hearted because I'm coming and willing to buy her property, so she's going to give me a $250,000 discount. I don't get it. It was on the market for over 4 years.
For 1.3
All
when
right,
you
I
bought
think
it.
now we're debating.
It was on the market for 1.3,
Okay.
and I didn't want to pay 1.3.
Okay, we're not going to
I don't know.
debate.
Is that?
For now, okay?
Who got that?
We're not debating, okay?
Okay.
So.
But I wanted to address that
I
she's saying I got a
understand that.
discount.
You addressed it, right, okay.
I bought a property that was on the market for 4 years at the price I wanted to buy it for.
That has nothing to do with what we're talking
Okay.
You know, that's how real estate is.
Do we have any new folks that, ma'am?
Okay, my name is Gloria Sylvia. I live in Canaan. I've lived there for 10 years. Mr. Sloan has made a point that the property will only be used for 8 weeks by the summer camp funded by the not-for-profit. What happens all the other weeks of the year? Who uses that property? Is it going to be left abandoned?
Okay, ma'am, we're addressing hardship again.
But
so,
he's
okay.
saying that
Well-
is the hardship that he has to pay the taxes and he has to do this and he has to do that. Is the not-for-profit going to pick up the taxes?
Yeah,
Will it belong to the not-for-profit, or will Mr. Sloan continue to own the property?
Okay, well, that's a different issue, however, so we're not. Yes.
I have an email from someone who isn't able to attend from Anna.
Your name, ma'am?
My name is Barbara Nagler. I live on Rock City Road, and as John Wapner said, I take pride in the fact that I've lived there since 1978. My 3 kids went through Chatham School successfully. The newspaper making me a little bit upset about its comments about the school. But this is about, this is from Anna, and I am absolutely opposed to the hardship. This is from Anna and Arthur Shaw, who live at 203 Thomas Road, who say they're sorry that they can't be here. This is addressed to the board, and I will leave this for you. We understand that Mr. Sloan is pushing for a special use permit. I ask that you not give it to him, that shall not be granted. And he says ignoring our moratorium and granting Mr. Sloan a hardship waiver makes him immune to our upcoming new zoning laws. Instead of reading the whole thing, in this manner, we urge you to deny the application. So, Nagler and Sloan.
My name is Uli Cole. I don't live in this community, but I've owned horses and had horses in this community for probably the past 25 years. I consider many of the people in this community my best friends. I spend my money here. I patronize local businesses. One of the things that I've always admired about Chatham is how amongst this plethora of New York State villages that have just wasted their environmental capital and ridiculously zoned themselves out of the very thing that made them unique, Chatham has somehow always managed to hold on to and preserve its rural beauty and its quality of nature. The very thing that makes it so appealing to so many people and that has created a community that is unlike any other, really unique. You know, people of different races, different colors, different ethnicities.
Please, can we address the hardship issue?
I am addressing
Okay.
the hardship.
All right, so, yeah.
I'm just being a little bit more eloquent about it because I'm an English major. But the point I'm trying to make is, you know, once you break something or undo it, you can't go back and say, I made a mistake. I truly believe the moratorium is the right decision to make. I truly believe that the new zoning laws are appropriate to put into place. Because going forward, it's really important for the quality of life in this community and for everybody in this community to be maintained and held to a specific standard. That's all I'm going to say, because otherwise what you have is not a democratic decision-making process. You have a decision-making process run on arbitrary decisions. That's all I'm going to say about that.
Hi, I'm Deborah Pierce, and I live in East Chatham, and I've only been here for 12 years. I support the moratorium, and I think that we should wait for the implementation of the new zoning laws. And I also have been asked to read a letter from Dr. Mishkin and his wife Alice Mishkin. Dear board members, as a Chatham rural property owner, my wife and I are firmly against the issuing of a hardship waiver for Mr. Sloan.
Hi, I'm going to read a letter also from somebody that was not able to be here. I'm Sue Tanner. I've lived here for 25 years plus, and I own 2 properties and pay taxes in Chatham. This is from Wendy Conway, who lives in East Chatham. Supervisor DeGroot and members of the Chatham Town Board, I'm writing to state my opposition to granting a hardship exception to the town's moratorium on special use permits on land along dirt roads in the case of Adam Sloan's application. I used to walk Chet's Hill years ago with my children and my sister's family who live on Thomas Road before that barn and house that now there were built. So I'm familiar with the property and the road. Since Mr. Sloan's original proposal, it has gone through many changes necessitated by the safety and environmental issues raised. So many they've been hard to keep track of, and I believe an indication of an ill-conceived plan. I hope Mr. Sloan's finances will not trump the deliberative process of safe and thoughtful development in the town of Chatham. A careful look at the reasons exceptions are granted is in order. Let the moratorium serve its purpose.
My name is Lynn Cross, and I'm in Old Chatham, a resident of 38 years. I own my property. I bought it myself. I pay taxes myself, and I run my nonprofit on that property. And I've never asked for any hardship or variances ever, nor will I think. I don't think so. But
see how this one comes out.
yeah, right. But I think I'm pretty close to what you're trying to do. And I did buy my property myself. And I do run a nonprofit. The nonprofit has been running for almost 30 years. And I do work with inner city at-risk youth. So 365 days a year. Thank you.
I think now that we've gone over this, and Mr. Sloan's repeated, his position several times, but we've narrowed it to Mr. Sloan saying that he spent $100,000, and as Mr. Murdoch has made it very clear, and I think all of us have had interactions with real estate in the past, and that is, you assume a risk. That is part of the capitalist system. You can never assume that government is not going to act. You have to assume that government will act. And in a community such as Chatham, that cherishes its environmental capital, you have to have done your homework and know that there's a comprehensive plan and know that Mr. Schwartz has been working on implementing zoning for 5 years and be very clear that government may come up and act. So you keep your contract contingent. And if it's contingent, then you are protecting yourself. Mr. Sloan did not protect himself, And you cannot convert the cost of doing business, that's all it is, whether it's $100 or $500,000. You cannot convert the cost of doing business, the assumption of that risk, and say to this board, you have to make it a hardship so that he can escape from the moratorium. There is no basis for that. And it doesn't matter whether the moratorium was enacted a month after he started or 6 months. He was still subject to the fact that this government can do it. It was legal. It was proper, notwithstanding all the police power and dire circumstance law that's been addressed here by Mr. Balcom in the letter. It's legal. It was your responsibility to do it. And he took a risk, made a mistake, paid some money for that, and he's now subject to some delay. And that cannot, according to your own law and its own language, be the basis for the grant of a hardship here.
I've come to a couple of these meetings. I'm Jim Buckley, and I live in Malden Bridge. I've been here 19 years. I've come to a couple of these meetings and have listened and haven't said much. But I've seen Mr. Sloan. He seems to be a successful real estate developer. And I don't think that you can throw yourself on the mercy of the board here and ask for a relief from the moratorium if it's something that you've created all yourself. And no reasonable or prudent businessman would buy a property, spend $1.3 million or $1.2 million, whatever it was, and not have a contingency to not go through with the purchase if he didn't get the permits in place before he bought it. And that's the sole issue really here. Any hardship that he has is completely self-imposed upon himself, and he can't throw himself on the mercy of the board. Thank you.
I have boarded at the facilities.
Name, please.
My name is Lauren Vitello. This is Lorelei. And I have boarded at the horse farm that Mr. Sloan bought. It's a beautiful horse farm. It's safe. It's on a dirt road. I come all the way from Avo Park to ride on a very safe, beautiful, welcoming street. And I've also boarded at Heather's place. She built a brand new facility across the street that was more, she has a lot of kids and a lot of ponies. And kids this age ride up and down that street. Now the hardship, I don't see why, if it was sold as a horse farm, why you couldn't keep it as a horse farm. I mean, that's why people come from all around, like Uli. We all come from far away to ride in a beautiful area. And you've got the hunt meeting at Heather's place. They ride up and down the street. There's lots of horses. And it's very safe for children this age. I think the hardship is that you change the use of the facility, and I don't see why you're asking all these people to pay for your mistake either. Woohoo!
Well, you said in your definition.
Jim's behind you there.
My name is Jim Johnson. I live on Rock City Road. I think the moratorium's been a good idea. When we had a meeting 3 months ago or whenever last winter, we looked at it as a timeout, given that new zoning rules were being developed and they were about to be presented. So it was a timeout to make sure that we made careful decisions based on the latest facts of our zoning thinking. Everyone here is basically saying the same thing that we said 4 months ago. I sort of don't know why all of a sudden Jesse, you seem to be bringing this up again as to what a hardship is and why this constitutes perhaps an exemption from that.
Jim, this is a hardship hearing. It has nothing to do with me.
Well,
it was requested by the applicant.
you're the supervisor of the town. You're the leader of the town. We're having this meeting because you called it.
Because the applicant.
And I don't think anyone else on the town board has changed their minds about this. It seems to be you.
Because under the moratorium law, the applicant is entitled, any applicant is entitled to come for a waiver hearing.
Very good.
Okay, my job is to administer that, whether it doesn't matter how I feel about it.
Great.
Okay.
4 months ago, you were very, very supportive of a moratorium.
Didn't say
And I don't want to
now.
see you flip-flopping on it again. Thanks.
Yeah, Jim, I think you're missing the point, but okay.
That's all right.
Yeah.
Just very quickly, you said when you led off this meeting that one of the criteria for having a moratorium was the endangerment of the health of the community. And by the Christ, if what just happened doesn't show the health of the community was endangered, God bless you for having that moratorium put in place and for taking the time to get it done right. Thank you.
Anyone else? Okay, well, then at this point, unless anybody has anything here, we'll declare the public hearing closed.
And as I said, I wanted to give you these letters before.
Oh, that's fine.
I didn't
Sure.
want to disrupt. These are letters that we've already seen before, but you'll have them handy.
This is, okay.
Yeah. One place for consultation.
Okay, so, excuse me. All right. We're still conducting our meeting. This, however, is now the town board meeting, okay?
So are you going to vote tonight on the hardship?
Well, that's what we're going to talk about right now, okay? So I think at this point, I'd like to consult with our attorney as to what he might suggest.
Sure.
Go forward.
The moratorium law requires that you issue a decision within 15 days. You've heard a lot of information tonight. You've had a lot of information over the last 3 or 4 months that you probably put aside for at least 2 months since there was that timeout. So I would say that it would be a smart thing to take a little bit of time and not make a decision tonight. If you want to be able to consider everything, you do have a workshop meeting, I think, in a week, 10 days.
On the 2nd.
July 2nd, yeah. What I would propose to do at that point is have actually a written resolution prepared. And what I would do is follow the same pattern that I've done in many other towns and in many other situations where boards have to vote, but they also need to have that resolution done in a very timely fashion. And so what I would propose to do is have attorney-client conversation with each one of you so that we wouldn't be violating the open meetings law. I would discuss with you what I would recommend be the criteria and the standard for the approval. And I'll talk about that in a moment. No, and I'll talk to you about that in a moment. And I will then prepare a written resolution based on a compilation of everyone's comments. Then at the July 2 meeting, we'll go through it word by word, page by page. If we need to change it, if we need to fix it, we'll do that. And then at the end of that, we can vote on whether that resolution should pass or not. If we don't, then we'll have to go back to the drawing board and come up with a new resolution. But at least you'd have something in hand that is a compilation of everyone's comments. Now, what I would suggest to you is something that's actually been suggested since March 31, as far as the criteria is concerned. And that is the criteria set forth in that Montgomery case, the town of Montgomery. It's a case that has been cited and accepted and used by both the Alliance, by Mr. Baker, and some submissions that he has made, and also by the applicant. And it's also something that we spoke about on the 31st, and I believe that the criteria that's in that law is the correct criteria, because it is solely about moratorium. It's not about use variances, it's not about area variances or other types of local laws. It is simply about a moratorium. And it is, in my opinion, right on point, and it, as I said, has been supported by both sides, both the applicant and the opposition. We'll talk about that, and we can go over that case. I've given it to you a couple of times, and you can read it again, and we'll discuss that. And then be prepared at the July 2 meeting, assuming that that fits your schedule and you want to give time for it at the July 2 meeting. I shouldn't presume to make your schedule.
Thoughts? Anybody?
Yeah, I'd like to take as much time as possible to deliberate all of this information. There are a couple of letters that we received this afternoon. First, I want to apologize for being delayed. I couldn't help it. But I haven't been able to read any of the material that came in later today. So I'm agree with council's recommendation that we wait until our workshop meeting. We have a lot to digest, and we owe it to people of the town and the applicant.
I'm there too. We just have gotten a lot of information. I want to say that many of the comments made tonight were, they're good, and they do give you something to think about. They were different than we've had before, and if we're going to be a good deliberative town board, and what I like to believe, we always strive to do the right thing, we need to have a little more time. So, fine with July 2nd.
Make the motion and we set up the workshop meeting to vote our resolution that night.
Let's do this before we get anywhere. Mr. Eggleston's probably there just to make sure we get them all. This fireman thing, we're going to make sure we can get the building.
Oh.
Yeah, we'll probably do that. We're just making sure we can get this space again for July 2nd.
Can I say, we're going to wait for public comment?
We're not having any more public comment.
Well, you will, of course, the meeting.
No. We're setting a date and the meeting will close. Okay, so we're good for July 2nd at 7 o'clock. That's a regular scheduled town board workshop meeting, although it's usually scheduled for the town hall. It's will be held here. Does anyone have anything else?
No. Thank you.
Okay. Motion to adjourn?
Wait a minute. Can we make a motion?
Yeah, do we need a motion?
It's a scheduled workshop meeting, so we probably.
Well, yeah, except we're doing it here.
We're just changing.
We're doing it here.
Yeah, we should do it notice.
Yeah, so we have to.
No, notice of motion. That was my question.
Well, we're going to do a resolution today. Yeah.
Okay, so I need a
Then we
second.
have the town board workshop.
Thank you. Somebody second.
Thank you, everybody, for coming.
Okay, all right.
Second?
We're moving that we have the town board workshop here.